Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we delve into the latest news on privacy, data protection, and cybersecurity from all over the world with the experts of the Privacy Rules Alliance and sometimes with some special guests. Today with me, I have Padraig Walsh from the Hong Kong-based law firm Tanner De Witt. And we are going to speak about the last of the topics I mentioned, which is cybersecurity, because there is a very recent news from Hong Kong related to a new piece of legislation on the topic. So first of all, Padraig, thanks a lot for being with us today.
Delighted to be here again, Alessandro, and greetings from the Pearl of the Orient.
Thank you very much, Padraig, as always. And I'm very interested to learn more about this piece of legislation you were mentioning to me in our closed door session preparing for this. So can you give us a bit of context on what we are talking about, also to our audience?
Certainly, yes. So this, although it's a new piece of legislation, it's been in prospect for a number of years in Hong Kong. It was announced as a part of the policy address of our chief executive back in 2022. And even before then, there were indications that the government was planning to prioritize cybersecurity and critical infrastructure protection in Hong Kong. And this is quite consistent with international trends. But it was new for Hong Kong in that it is the first piece of horizontal legislation that would be introduced to deal with the protection of critical infrastructure and computer systems. There had been sectoral regulation before in areas such as the banking sector, the communication sector, and also the securities sector and insurance sector, but it was sectoral regulation as opposed to something that was more horizontal in nature. And really the purpose of the legislation is to introduce something that applies across the economy as a whole, but as a starting point, as a baseline point to enhance and encourage consistent standards in respect of the protection of core computer systems and critical infrastructure operators.
Perfect, Padraig. Thanks a lot for giving us the context on these. Let's go a bit deeper into the legislation. So, which are the contents of it, and the key ones at least, and who is impacted? Because this is normally the first question that we receive. People want to know which are the type of companies that normally falls within the scope of a law.
So, what is clear from the published draft bill is that it is directed at an organization level, and it's going to be directed towards large organizations. Now, those so for instance, SMEs are not really the target of the legislation, and also the government is expressly excluded, but they're because they are already served by administrative policies that are in place already. The designation of critical infrastructure operators will occur in two categories. One category is designed according to industry sectors. There are 8 sectors that have been identified. There's energy, information technology, transport in 3 descriptions: land, air transport, and marine transport, banking and financial services, healthcare services, and telecommunications and broadcast services. So those 8 industry sectors, what will happen is that the Security Bureau, or the more specifically the commissioner that's appointed under this particular legislation, will go through a process of designating critical infrastructure operators within those 8 industry sectors, which are intended to be large organizations. And there's a second category. That second category is a little bit, I guess, in terms of how it's described, a little bit more ad hoc, but it's clear what it's directed towards. And those are infrastructures which relate to critical society or economic activities. What's intended there is things like large sporting events or things of that nature, or maybe business parks or large kinds of infrastructures of that nature, that they may well become designated within category 2. So those are the targeted organizations. You can see that it's really aiming for, I guess, what you might describe as businesses that will be able to tolerate and sustain the systems compliance procedures that are going to be required under the legislation.
I see. And in this regard, you mentioned many companies, type of targeted companies or organizations that deal with great amounts of personal data. So is there any overlap with the personal data law and this new law on cybersecurity?
It's quite clear that there's intended to be no overlap, though you can expect that there might be some degree of just operational coordination. What the legislation is looking at is not the data as such that's within the infrastructure systems, as in that's not really the target. It's looking at the critical computer systems themselves. Now, it may well be that data is involved in that, but it's not intended to be dealing with, for instance, personal data specifically. And that has been quite clear from the outset. That's why there will be a new commissioner and a new commissioner's office that will be set up, established, and empowered under this legislation, as opposed to a division, for instance, of the PCPD, which is a privacy regulator in Hong Kong. The legislature did not go down the route of just extending the scope of the Privacy Commission. Instead, this is going to be a new regime focused instead. I mean, that largely makes sense because the purpose of cybersecurity is actually different in many ways than the purpose of personal data protection. It's more about maintaining confidentiality, integrity, availability of systems, as opposed to ethical compliance around collection and use and processing of personal data. So it's different purposes.
Perfect. Thanks a lot. In this regard, you are opening me to another question that is a minor question, but I think it's still relevant in this context, which is the role of the legal expert there. Because one of the things that happens quite often in these cases is that people tend to think, okay, I just need a cybersecurity expert then that support me, so an IT person that protects my system. But maybe it's important to let our audience know why there should always be a legal expert involved in those activities as well.
Certainly. Let me explain that in the context of the obligations that arise in respect of designated CIOs under the legislation. So there are three streams of obligations, but to answer your question, let me focus on the third stream first, which is a very Irish thing to do, put the last one first. So the third stream of obligations relates to incident reporting. If and there's an obligation that a serious incident must be reported to the commissioner within 24 hours of the incident occurring, and for other incidents that are within that meet the threshold required by the legislation, then within 48 hours of becoming aware of the incident. Now, certainly you need to make those notifications, but what notifications often lead on to and what's contemplated by the legislation is that the commissioner will inquire into the incident, will seek to understand the reasons why, will seek to see whether there are any infractions of obligations under the ordinance or otherwise that occurred, and will therefore take enforcement action arising from that inquiry and from that investigation. So if you know that you are potentially open to an investigation by a competent regulator, one of the things that particularly large organizations which have a number of stakeholders and a number of interests that they seek to make sure that they balance the interests of fully, one of the things they would want to do is to be able to have more, I guess, control in respect of how those types of investigations occur. And one of the things that helps is if you have a lawyer, an external lawyer that's advising in respect of an incident, once they are engaged, the work they do in respect of advising the client and responding to the incident in respect of the nature of the investigation and so forth is subject to legal professional privilege. And what that means is that if the lawyer engages, for instance, the technical team that does the incident response, then when the report is prepared in respect of the causes of the incident response, that report can be also subject to legal professional privilege because it was obtained, instructed, under the engagement of a law firm and for the purpose of delivering legal advice. And this can help in respect of not not necessarily being uncooperative and, drawing a veil down in respect of how you respond to the regulator, but giving you more optionality in respect of how you report in response to the inquiries that are made by the competent regulator. So the answer to that is that it's really around the benefits you can derive from legal professional privilege in terms of managing a response to a regulator's inquiry.
Yeah, and in this regard, let me quote one of our colleagues, in this case from Belgium, while we were speaking about NIS2, which is a similar regulation in the EU context, that was saying we are still speaking about laws, so legal requirements. So whenever you have to deal with authorities in relation to that, you need someone that know how to speak the language that is required to comply with it and to explain what has been done by the company. In terms, you were speaking about several obligations. Is there anything else you would like to add in this regard? Otherwise, I have one last question to make to you that is related to the timeline that we have. Is it this law already applicable, or when is it going to be applied or fully enforced, let's say?
So on this occasion, I will deal with your first question first. So you asked what were the obligations in general. There are three categories of obligations. I mean, there's other things in the legislation, but in terms of primary obligations, the first category is organizational obligations, sensible things like you have to, if you are operating in Hong Kong as a CIO, you need to have an office in Hong Kong, and you need to make contact people available to Hong Kong, to the commissioner, and a couple of other organizational obligations. Then you have preventive obligations. So these are things like you need to do an annual security risk assessment, and then a biannual independent assessment in respect of your security capabilities. And you have to have a management plan in respect of your infrastructure and your security standards and incident response planning and so forth. And then the third category of obligations around incident reporting, things such as you need to do simulations in respect of incidents themselves, and you also need to have reporting obligations to the commissioner if an incident happens. So those are the basic obligations in respect of the legislation itself. Now, in terms of the legislative timeline, as we speak at this moment, it's going through its second reading with the Legislative Council, which is the last of the readings. After this, after the requirements of this second reading are fulfilled, then it is open for the legislation to be gazetted and to be enacted. But there will be a grace period for compliance. So we know that the legislation is close to final form. We know that it will be on the books within this year, most likely even before the summer. And we also know that within a short period afterwards, there will be more codes of practices and guidelines that will be published by the commissioner in order to prepare the designated CIOs for the life ahead in respect of the regulated environment they will be operating in.
Perfect, Padraig. Thanks a lot. We are running out of our time. I think one important thing to mention is that, in particular, in relation to your last point, is it seems like there is a lot of time, but it's not that much if you think about the complexity of the topic we are speaking about, meaning that there is really an entire new world behind complying with cybersecurity laws and a lot of processes and activities. So at least it might be good to start assessing which is the stage of each of the companies that might fall within the scope of this legislation already now. I would like to thank you very much for being with us today, for giving us this very clear overview on this news coming from Hong Kong. I would like to thank our audience for being with us today, and I look forward to see you all with our next Privacy Espresso episode. Thanks a lot for your attention, and bye again, Padraig.